1 2 1 2 1 2 1 2 1 2 1 2 1 2 1 2 1 2 1 2 1 2 1 2.
Okay. Good. Morning. Subcommittee on Regulatory Reform, Commercial and Antitrust Law will come to order. Good morning, everyone. Without objection, the chair is authorized to declare a recess of the committee at any time, and we welcome everyone to today's hearing on H.R. 5063, the Stop Settlement Slush Fund Act of 2016, and I now recognize myself for an opening statement. Welcome to this hearing on the Stop Settlement Slush Fund Act of 2016. The bill titled sums up the issue. A Judiciary Committee investigation has revealed that DOJ is requiring settling parties to donate money to third-party groups. At issue are large sums of money, close to $1 billion in just the last 2 years. Of that, over $500 million has already been dispersed or is committed to be dispersed. I purposely did not make this hearing about groups that received the money. I did not want to distract from the central issue. And I feel the central issue is the harm that these provisions do to Congress as an institution. The spending power is Congress's most effective tool in reining in the executive branch. This is true no matter which party is in the White House. A Democrat-led Congress passed the Cooper Church Amendment to end the Vietnam War. More recently, Congress used a funding restriction to prevent the transfer of Guantanamo Bay prisoners to the United States mainland. Bipartisan funding restrictions were passed to block lavish salary and conference spending by federal agencies and grantees. This policy control is lost if the executive gains authority over spending. Serious people on both sides of the aisle understand this. Consider Todd Peterson, former Deputy Assistant Attorney General for the Office of Legal Counsel in the Clinton administration. He warned in 2009 that because the Department of Justice has such broad settlement authority, it has the ability to use settlements to circumvent the appropriations authority of Congress. In 2008, a top Republican DOJ official circulated a memo to federal prosecutors restricting mandatory donation provisions because they can create actual or perceived conflicts of interest and or other ethical issues. So again, serious people understand that this is fundamentally a bipartisan institutional issue. Indeed, the language on which this bill is based passed the House last year by a voice vote. The Stop Settlement Slush Fund Act of 2016 prohibits settlement terms that require donations to third parties. It states explicitly that payments to provide restitution for actual harm directly caused, including harm to the environment, are not donations. As a former federal prosecutor, I am acutely aware of the needs of DOJ in negotiating settlements. Now, as a congressman, I am also aware that a line has to be drawn. The common sense bill merely issues that settlement money goes either to direct victims or to the U.S. Treasury so that the people's elected representatives can decide how best to spend it. I understand we could differ on the details, but today is not a markup. This is an opportunity to hear from expert witnesses to ensure that the legislation has the proper scope. Let us work together from a common premise. So I call my colleagues to join me in defending the fundamental principle. Elected, accountable members of Congress should decide how federal funds are spent. I am pleased that every Republican subcommittee member is already a co-sponsor. I hope my Democrat colleagues will soon join this important effort. I thank our witnesses for appearing and look forward to the discussion. Chair now recognizes the ranking member of the Subcommittee on Regulatory Reform, Commercial and Antitrust Law, Mr. Johnson of Georgia, for his opening statement. Sir.
Thank you, Mr. Chairman. H.R. 5063, the Stop Settlement Slush Funds Act of 2016, would remove an important civil enforcement tool available to agencies to hold corporations accountable for the general harm caused by unlawful conduct and would create waves of uncertainty, delay, and needless litigation in the enforcement of civil law. H.R. 5063 would have potentially disastrous consequences on the remediation of generalized harms in civil enforcement actions. For unlawful conduct with systemic harms, such as environmental catastrophe or an environmental catastrophe, settlements provide a mechanism to provide for the remediation of generalized harms through offsets and other indirect remedies. Similarly, parties seeking to regain public trust may also wish to include voluntary auditing requirements in settlement agreements that ensure that similar violations do not occur in the future. Joel Mintz, an expert in environmental law and enforcement, observes that these settlements, quote, can create a win-win scenario for all parties involved, including regulators, regulated companies, and local communities, end quote, by creating a flexible regulatory climate and repairing, quote, corporate public images that would otherwise be further harmed by negative environmental publicity, end quote. For example, in 2012, the Mitsui Oil Exploration Company settled its liability for violations of the Clean Water Act resulting from the Deepwater Horizon oil spill. In addition to civil penalties, Mitsui Oil agreed to facilitate land projects in several states, including Texas, Mississippi, Alabama, Louisiana, and Florida, to conserve critical habitat within the Gulf of Mexico. In this case, and others like it, donations under settlement agreements serve as a critical tool to remedy a general harm and provide the settling party with an opportunity to re-earn the public's trust. H.R. 5063 would eliminate these donations in both existing and future settlement agreements. This is true even in cases where the settling party seeks a donation to offset its unlawful conduct or where a party's harmful conduct could not otherwise be remedied. This legislation is also unwarranted. It's also an unwarranted encroachment on the prosecutorial discretion of civil enforcement agencies. The exercise of enforcement discretion is a traditional power of executive branch agencies. This authority provides broad prosecutorial flexibility to civil enforcement agencies when crafting settlement agreements within the scope of their statutory authority. It is little surprise that the Supreme Court has consistently held that the exercise of such discretion is a core function of the executive's power under the Take Care Clause, as it did in Heckler versus Cheney, where the court observed that the characteristics of a decision of a prosecutor in the executive branch have long been regarded as the special province of the executive branch, inasmuch as it is the executive branch who is charged by the Constitution to take care that the laws be faithfully executed. Under this constitutional norm, agencies' prosecutorial discretion to settle potential civil actions extends to requiring donations in settlement agreements. Additionally, settlement agreements may exceed the remedies identified in an agency's underlying statute so long as they relate to the agency's statutorily authorized prosecutorial objectives, which generally requires that donations have a sufficient nexus between the underlying violation and the proposed remedy. H.R. 5063 represents a severe departure from these core principles, raising separation of powers concerns and threatening to curtail agency discretion in the enforcement of the law. In closing, I'd like to thank our witness for appearing today. I'd like to welcome our former colleague, Dan Lungren, back to the other side, and I yield back the balance of my time.
Thank you. The chair now recognizes the chairman of the full Judiciary Committee, Mr. Bob Goodlatte of Virginia, for his opening statement.
Well, thank you, Mr. Chairman. I appreciate your holding this hearing. 18 months ago, this committee commenced a pattern or practice investigation into the Justice Department's mortgage lending settlements. We found that the Department of Justice is systematically subverting Congress's spending power by requiring settling parties to donate money to activist groups. In just the last 2 years, the Department of Justice has directed nearly $1 billion to third parties entirely outside of Congress's spending and oversight authority. Of that, over $500 million has already been dispersed or is committed to being dispersed. In some cases, these mandatory donation provisions reinstate funding Congress specifically cut. Whether the beneficiaries of these donations are worthy entities or not is entirely beside the point. The Constitution grants Congress the power to decide how money is spent, not the Department of Justice. This is not some esoteric point. It goes to the heart of the separation of powers theory and Congress's ability to rein in the executive in practice. Certainly, the Department of Justice's authority to settle cases necessarily includes the ability to obtain redress for victims. However, federal law understands victims to be those directly and proximately harmed by a defendant's acts. Once those victims have been compensated, deciding what to do with additional funds extracted from defendants becomes a policy question properly decided by elected representatives in Congress, not agency bureaucrats or prosecutors. It is not that Justice Department officials are necessarily funding bad projects. It is that, outside of compensating actual victims, it is not their decision to make. We have brought these reasonable concerns to the Department of Justice, but rather than suspend the practice of mandatory donations, DOJ has doubled down. Just 2 weeks ago, a major DOJ bank settlement required $240 million in financing and/or donations toward affordable housing. It is time for Congress to take action to end this abuse. The Stop Settlement Slush Funds Act of 2016 bars mandatory donation terms in DOJ settlements. It is a bipartisan bill. It makes clear that payments to provide restitution for actual harm directly caused are not donations. It explicitly references the environmental context where the injury to the environment may be diffuse and there may be no identifiable victims. The bill deals with this by explicitly permitting payments to remediate environmental damage. If direct remediation of the harm is impossible or impractical, the violator is not let off the hook. The full penalty is paid, but into the Treasury. The principle is clear, but the details need to be studied. I am pleased that we have an expert panel today to offer views. I am particularly interested to hear their thoughts on the scope of the bill. It covers civil settlements. Is that sufficient? What about the language permitting remediation of harm directly and proximately caused? Does this impose a sufficiently tight nexus between the payment and the offense to prevent further DOJ mischief? So I'm eager to hear from our witnesses, and I thank them for coming. And I also want to thank all of the bill's co-sponsors, in particular Chairman Marino, Representative Peterson, Chairman Culberson, and every Republican member of this subcommittee. It's also a pleasure to welcome back to the Judiciary Committee my longtime friend and former colleague, Dan Lungren, who I'm sure has a keen interest and insight into this issue, and I welcome the other witnesses today as well. Thank you, Mr. Chairman. I yield back.
Thank you. Chair recognizes the full Judiciary Committee ranking member, Mr. Conyers of Michigan, for his opening statement.
Thank you, Chairman Marino, and I join all of us in welcoming back Dan Lungren in his newer capacity. He was an outstanding member of the Judiciary Committee, and we look forward to his testimony. Today's hearing concerns legislation that would prohibit the enforcement or negotiation of any settlement agreement requiring donations to remediate harms that are not directly and proximately caused by a party's unlawful conduct. The proponents of this bill assert that the Justice Department and civil enforcement agencies use such settlement agreements to unlawfully augment their own budgets as an in-run around the congressional appropriation process. I believe this bill is a seriously misguided effort for a number of reasons. To begin with, these settlement agreements have been successfully used for example, to facilitate an effective response to the predatory and fraudulent mortgage lending activities that nearly caused the economic collapse of our nation. Settlement agreements with two of these culpable financial institutions, Bank of America and Citigroup, require a donation of less than 1% of the overall settlement amount to help affected consumers. The majority initially claimed, however, that the Justice Department used these settlement agreements as a vehicle for funding activist groups. Notwithstanding the production of hundreds of pages of documents by the Justice Department, along with hundreds of pages of documents produced by private parties, the majority's investigation has not produced any evidence that the government included unlawful or politically motivated terms in its settlement agreements with Bank of America or Citigroup, let alone slush funds. In the absence of any facts to support their initial claims, the majority now asserts that the Justice Department and other agencies have augmented their appropriations through civil enforcement. But existing law already prevents agencies from augmenting their own funds through civil enforcement. These laws require that donations and settlement agreements have a clear nexus to the prosecutorial objectives of the enforcement agency. And both the Government Accountability Office and the Congressional Research Service conclude that the settlement agreements providing for secondary remediation do not violate Congress's constitutional power of the purse. And finally, I'm also very concerned that this measure would have potentially disastrous consequences on the remediation of systemic harms in civil enforcement actions. Settlement agreements allow parties to resolve their civil liability by voluntarily remediating the harms caused by their conduct. In the context of environmental enforcement actions, for example, parties may voluntarily agree to undertake restoration projects to protect local ecosystems in order to offset environmental damage. Moreover, for some unlawful conduct, such as, for example, employment discrimination, secondary remediation of harms may be the only remedy available for system violations of the law. Employment discrimination lawsuits typically affect the interests of employees who are not parties to an action. Secondary remediation in these cases serves as an important tool to protect victims of workplace harassment and establish lawful workplace norms through voluntary compliance and training programs. So you can see I have some serious concerns about this legislation, but I thank our witnesses for being with us today, and I look forward to hearing their testimony. Mr. Chairman, I yield back.
Thank you. Without objection, other members' opening statements will be made part of the record. I will begin by swearing in our witnesses. Before I introduce them, would you please stand and raise your right hand? Thank you. Do you swear that the testimony you're about to give before this committee is the truth, the whole truth, and nothing else but the truth? So help you God. Please be seated. Let the record reflect that all the witnesses have responded in the affirmative. And now I'm going to just take several minutes to introduce all three of you at once, and then we'll start with Congressman Lungren, but I like to refer to you as General, because you know how we prosecutors are. So. As a matter of fact, all of you as along those lines. But Daniel Lungren is a principal at the Lungren Lopina LLC. Mr. Lungren has served 9 terms as a member of the U.S. House of Representatives from California, as well as 2 terms as Attorney General of California. In Congress, he was a member of the House Judiciary Committee, House Intelligence Committee, and was a senior member of the House Committee on Homeland Security, where he worked on a number of important legislative reforms. As Attorney General, Mr. Lungren led an office of nearly 1,000 lawyers with an annual criminal and civil caseload of approximately 50,000 cases. In that capacity, Mr. Lungren achieved record settlements under California's environmental laws, including the largest environmental settlement up to that time in California in a toxic spill case. He also won 2 of the largest settlements ever under the Federal Clean Water Act and the Federal Superfund Law. Mr. Lungren earns his bachelor's degree from the University of Notre Dame and his law degree from Georgetown University Law Center. Welcome, Congressman. Professor Paul Figley is the Associate Director of the Legal Writing and Rhetoric Program and Professor of Law at the American University Washington College of Law. Prior to joining the faculty at Washington College of Law, Professor Figley served as U.S. Department of Justice litigator for 3 decades, with the last 15 years as Deputy Director in the Torts Branch of the Civil Law Division. At Justice, Professor Figley represented the United States and its agencies involving tort, national security, and informational law. Professor Figley earned his bachelor's degree from the Franklin and Marshall College and his law degree from the Southern Methodist University School of Law. Welcome, Professor. Professor David Uhlmann, am I pronouncing that correctly, sir? Thank you. Is the Director of Environmental Law and Policy Program at the University of Michigan Law School and is the Jeffrey L. Liss Professor of Practice. Prior to joining the Michigan faculty, Professor Uhlmann served for 17 years at the United States Department of Justice and the last 7 as Chief of the Environmental Crimes Section, where he chaired the Justice Department's Environmental Crimes Policy Committee. Professor Uhlmann has published in various national publications and leading law journals and has testified before Congress. Professor Uhlmann graduated with a bachelor's degree in history with high honors from Swarthmore College and a law degree from Yale Law School. And Professor, welcome. Each of the witnesses' written statements will be entered into the record in its entirety. I ask that each witness summarize his testimony in 5 minutes or less, and to help you stay within that 5 minutes, there are lights in front of you, but as I do on occasion when I'm out there making a statement, I pay no attention to the lights. So what I will do is very diplomatically sort of pick up the hammer here and just give a little tap and ask, by doing that, asking you to wrap up. So I will now recognize the former Attorney General of California, former Congressman, the Honorable Dan Lungren, for his opening statement.
Thank you, Mr. Chairman, and thank all members of the subcommittee, particularly Chairman of the full committee, the ranking member of this committee, the ranking member of the full committee, who I refer to as Chairman Emeritus from time to time. Like many, well, first of all, let me just say I'm going to try and give a perspective of both a former member of Congress and Attorney General in this matter. And like many of you, I've observed with concern the American public, who appears to have lost some considerable faith with the present state of our politics and governance. In other words, a healthy skepticism of government, which I believe is enshrined in our opening documents, founding documents, has been replaced in some cases with outright cynicism, and that is, in fact, harmful to our democracy. There are many reasons for this corrosive development, but they're too numerous to mention here, but I do believe it established a context for our discussion today. I fear the growing trend in law enforcement is contributing to the erosion of the public's trust that it will receive impartial and fair justice, and I think also, particularly in the case that we're talking about here today, it is intruding on the core prerogatives of the Congress as well. There are about 4 points that I make in my written presentation. The first deals with the specific subject matter we're talking about here, where executive branch agencies now use settlements of enforcement actions to fund private parties whose activities further the policy, and I believe in some cases the personal goals of the agency officials. Secondly, law enforcement officials and their offices increasingly have a direct financial stake in the outcome of prosecutions. At the federal level, we talk about asset forfeiture and equitable sharing programs, which allow law enforcement agencies to retain a share of their forfeiture proceedings. Let me be clear. I was present at the creation of the '84 iteration of that law and proudly claim some share of authorship. But I think abuses have arisen and they must be dealt with, and I think this Congress must review them in some detail. Third, such practices have not been limited to the federal government. State enforcement officials, including state attorneys general, have used settlements to fund their own operations and create new grant programs outside their state legislative processes, and sometimes in conjunction with the federal government. Fourthly, there is a modern 24-day news cycle that's transformed the public information domain and how public officials react. The pressure is even greater on public officials, particularly those who are law enforcement. How do we help them make sure that they are doing justice? How do we help them make sure that they are making their decisions without fear or favor? I think there's at least 3 things we ought to look at: clear rules of the road. Secondly, defendants given a fair chance to defend themselves rather than be subjected to multiple overlapping enforcement actions that leave no choice in some cases but an unfair and unjust settlement. And punishments should fit the offense, and in Congress it ought to be looked at as to whether or not we have excessive demands that are coercing settlements from the innocent. Let me go back to my first point and the subject of specific legislation before this committee. Does anyone believe that these donations are freely given, voluntary expressions of support for these organizations? No, they're coerced. Coerced payments to the entities mandated by the officials acting with the full power and majesty of the government. Let me just give a few examples of these grant phenomena. In 2012, the Department of Justice forced Gibson Guitars to pay a $50,000 community service payment to the National Fish and Wildlife Foundation, even though the foundation was not a victim of the alleged crime and had no direct connection with the case. It was simply a non-governmental organization that DOJ employees liked. In 2006, the DOJ forced a wastewater plant that had been accused of violating the Clean Water Act to give $1 million to the United States Coast Guard Alumni Association. Looking at the case, I can find that the association had absolutely no connection and had suffered no harm, direct or indirect. This committee, I think, is to be commended for your investigation into the contours of DOJ's settlements with our country's largest banks. Look, we could go through detail after detail on this, but the Bank of America settlement is most curious to me. The bank was to set aside $490 million to pay any potential tax liability to be incurred by their customers occasioned by loan modification or forgiveness. In other words, the case that if there's a forgiveness, the net result of the forgiveness is viewed as a income to the individual who held the loan, and the government comes after them for taxes. So I can understand why that was done. However, Congress, in its infinite wisdom, I always thought we were going to do this, extended the non-tax liability in those cases. So what happened to the $490 million? Well, they were donated to the Neighborhood Works America in interest on lawyers' trust account groups. Look, some of us here, those on the committee and I might agree with the worthiness of these organizations. However, is that the Department of Justice's decision to make? I would argue that under the Constitution it is not. I would argue that in my years in Congress I saw some of the core prerogatives of the Congress ceded either by omission or commission to the executive branch. And thirdly, I would just say that as the American people are looking at their institutions of governance on all levels, Congress ought to at least follow the Constitution. And as Senator Byrd said, appropriations go to the legislative branch because it is the most open and responsive or representative branch of our government. So we're talking about accountability and transparency. Thank you for your consideration.
Thank you. Professor Figley, please.
Thank you, Mr. Chairman and members of the committee. Congress's power of the purse and its authority under the Appropriations Clause to direct where government money will be spent is a key component of our constitutional system of checks and balances. The authority has roots in the Magna Carta, and it was a substantial factor in the development of constitutional democracy in England. The colonial legislatures leveraged their taxation power into the power of appropriation, laying the groundwork for American independence. The authors of the Constitution vested the right of appropriation in the legislative branch. They did so, as James Madison explained in The Federalist No. 58, to ensure that government is directly accountable to the people and to provide Congress, quote, a key check on the power of the other branches, close quote. The current practice of allowing government attorneys to negotiate settlements that require other parties to make payments to individuals or entities who are not involved in the underlying dispute or damaged by the defendant's action circumvents the appropriations process and undermines Congress's power of the purse. The practice allows those government lawyers to provide payments to persons or entities without congressional authorization to do so. The practice creates numerous difficulties. As a practical matter, federal attorneys are poorly suited to choose which persons or entities should receive a financial windfall. The system is unfair to other potential beneficiaries who did not collect the handout. The system lacks transparency. What factors determine which group will receive a payment? Who makes that decision? Are political considerations weighed? As the U.S. Attorney's Manual recognizes, the practice creates, quote, actual or perceived conflicts of interest and other ethical issues, close quote. One such issue is the potential for settlement payments to be directed to political allies or to further the political or personal ends of the government attorney. A second ethical issue is the risk that payments to unrelated third parties will be strong-armed from defendants who seek to avoid publicity or debarment. The fallacy of tolerating this practice is reflected in settlement decisions like those requiring private entities to provide a $1 million endowment to the U.S. Coast Guard Academy, a $5 million endowment to the Seton Hall Law School, and a $2.4 billion payment to the National Fish and Wildlife Foundation. Such windfalls should not be bestowed by executive branch attorneys negotiating settlements with anxious defendants. Congress, acting with its power of the purse, has the right to determine which payments should be made. For these reasons, I support enactment of the Stop Settlement Slush Funds Act of 2016. I encourage the committee to consider clarifying the act, that the act would apply to settlements in both civil and criminal matters that require private defendants to make donations or payments to persons or entities not involved in the dispute or injured by the defendant's actions. Thank you.
Thank you, sir. Professor Uhlmann.
Thank you, Chairman Marino, Congressman Johnson, and members of the subcommittee for inviting me to testify today. A case I prosecuted at the Justice Department, where I served for 17 years before becoming a law professor, highlights why third-party payments often are needed to address the harm caused by regulatory violations. The case involved John Morrell and Company, which until the mid-1990s was the largest employer in the state of South Dakota. Morrell operated a slaughterhouse in Sioux Falls that discharged waste into the Big Sioux River. Under the terms of its Clean Water Act permit, Morrell was required to treat its waste to limit the concentration of ammonia, nitrogen, and other pollutants that could harm the river. The permit also required Morrell to test its waste at least 3 times each week and to report all sampling to EPA and the state of South Dakota. Instead, over a period of more than a decade, Morel officials engaged in a conspiracy to violate the Clean Water Act, discharging ammonia at levels nearly 40 times those allowed under the law, and lying to conceal those violations. I provide additional details about the case in my written testimony, but suffice to say that the illegal scheme was so well known within the company that the senior vice president in charge of the Sioux Falls facility repeatedly asked, "Who's going to jail this month?" when he signed the falsified discharge monitoring reports. The Justice Department prosecuted Morel under the Clean Water Act, but could not prove the extent of the harm to the river because Morel had concealed its violations for years. With the approval of the federal district court, the Morel plea agreement created the Big Sioux River Environmental Trust Fund to support cleanup efforts on the river and to restore recreational opportunities for communities harmed by the company's misconduct. Morel paid a $2 million criminal fine and $1 million in restitution and community service to the Big Sioux River Environmental Trust Fund. While Morel was a criminal case, it is instructive about the shortcomings of the proposed legislation. Environmental violations cause significant harm to our communities. In some cases, the harm can be addressed by restitution to individuals, which the proposed legislation would not disturb. In the overwhelming majority of cases, however, the harm is generalized. Air is polluted. Water is contaminated. Everyone in the community suffers, and third-party payments are the only remedies. These are not minor violations, but serious breaches of the rule of law that cause real harm and have real consequences. I have three concerns about the Stop Settlement Slush Fund Act of 2016. First, the bill would undermine the Justice Department's ability to hold corporations responsible for the harm caused by violations of our environmental laws, but also our civil rights laws, our consumer protection laws, food and drug laws, and antitrust laws. The bill prohibits only donations, but it never defines that term, which could be construed by courts to apply to all third-party payments. In addition, while the bill exempts payments for actual harm, it does not state that actual harm includes generalized harm like what occurred in Morel. Second, the bill's focus on civil settlements rests on a faulty premise, namely that generalized harm occurs in criminal cases, but not in civil cases. There's no principled reason why corporations should be required to remediate the harm they cause in criminal cases, but not required to do so in civil cases. If harm only could be addressed in criminal cases, it would encourage law enforcement personnel to pursue criminal prosecution in matters that might otherwise be resolved by civil settlements, which would risk overcriminalization of regulatory violations. Third, Congress is simply not able to legislate to address all harm that occurs in our communities every time a regulatory violation occurs. No one disputes that Congress has the power of the purse, and for that reason, the Miscellaneous Receipts Act and the Anti-Deficiency Act impose significant limits on third-party payments in both plea agreements and civil settlements. But corporations who engage in wrongdoing, not the general public, should be responsible for addressing the harm caused by their violations. I share the subcommittee's desire to ensure that all third-party payments serve the public interest and law enforcement objectives. Law enforcement is a sacred trust, and officials who have the honor of representing the people of the United States must serve the common good and not their personal interests. In my view, third-party payments must be negotiated separately from criminal or civil penalties, must address the harm caused by violations, and cannot augment federal agency programs. I also might impose a limit on the percentage of funds that could be devoted to these payments, but those terms are nowhere to be found in the proposed legislation. Thank you again for inviting me to testify. I'd be pleased to answer your questions.
Thank you. I'll now recognize myself for my 5 minutes of questioning. First of all, it's a pleasure to be talking with brother prosecutors. I do want to make clear that we kept the bill as narrow or simple as possible, because we want to hear what you have to say as far as perhaps expanding on issues. And just through your opening statements, I can see areas where we need to expand: civil, criminal. Do we say funds instead of donations and explanations? But as a prosecutor, I would like to first ask, there's been some concern about this curtailing prosecutorial authority. And as a prosecutor, as far as discretion is concerned, we all know that there are multiple ways to resolve a case. So how would this not resolve a case? Why do you think it would prevent, if you do, why do you think it would prevent a prosecutor's discretion in moving forward with a case? And I'd ask Congressman Lungren if you could address that, and each one of you, please.
Well, in answer, I would say I don't think it unnecessarily restricts prosecutors. As I understand the way the bill stands now, it prohibits mandatory donations but not redress to individuals as affected. One of the arguments I see that has been made is that in criminal cases this has been allowed, but certain criminal statutes have very specific authorities to do this, and you have to say, why would the Congress give them specific authority if in fact they have general authority? I think it's because Congress looked at those specific cases to say, in these matters, we can allow a more generalized redress. And the third point I would make is this. If, in fact, the harm has been done to the public and is so diffuse that you can't identify those who are the proximate sufferers of it, if you can prove in court, as a legal matter, that damage has been done but it is diffused, then the money ought to go to the federal government, and the federal government ought to decide through the regular appropriation process how those funds ought to be expended. It is, look, it's a natural thing. As Attorney General, I like the great flexibility I had, but I remember the largest case we did, I think, was the famous tobacco case. California got the largest amount of money from that, but as I recall, I was not able to direct those funds under the California Constitution. They went into the general fund. I would have liked to have. I thought I had a superior idea as to where they should go. Unfortunately, the California Constitution said otherwise. I think similarly, the U.S. Constitution, as Senator Byrd explained in his statement that I have in my statement, it is the most representative and the most open of our branches.
Okay. Thank you. Professor Figley?
I think Congressman Lundgren's last point is exactly right. If there has been general harm, money can go into the general treasury, and Congress can decide the best places to spend it, as opposed to having any government, any Department of Justice official make that determination.
Okay, thank you. Professor Uhlmann?
So Congress has already determined that criminal penalties go to the Crime Victims Fund. Civil penalties go to the Civil Judgment Fund. So the idea that additional monies that might be paid as part of either plea agreements or civil settlements is somehow going to revert back to the federal treasury for Congress to then reappropriate is a complete misnomer. Would require changing how all criminal penalties are directed by Congress, would require changing how all civil settlements are directed. But it also misses a broader point, which is Congress also has said that restitution to victims takes priority over all penalties in both in the criminal system. And as I've already discussed, and as we can certainly discuss at greater length, it's simply not always possible to identify individual victims to meet the requirements of federal law. The environmental example is the easiest one, but the same concerns arise in other regulatory schemes. And so, to your question, Mr. Chairman, we would deprive prosecutors and civil enforcement of the attorneys of their ability to address the generalized harm that occurs in these cases. So we'd get half a loaf in every case. We'd get criminal penalties or civil fines. We'd get individualized restitution. We couldn't address the harm to our communities. And there are hundreds, if not thousands, of these violations every year. Congress is not going to be able to legislate for each one of them. And so this is, I think, the best way, clear rules about what is allowed and what isn't allowed in these third-party payments is the best way to proceed, not by prohibiting them as this legislation would do.
Okay, I'm going to take some liberties here if my colleagues don't mind. We don't have a full panel here. So you do understand that if a specific victim can be identified, that you prosecutors have the authority to address that issue and recoup funds for those specific individuals. But if a specific entity cannot be identified, or if there is collateral damage, I still have an issue with an agency, and as thinking as a prosecutor, as we do, that discretion or that authority is very powerful and good to do 99.9% of the cases. But Congress does appropriate. And I err on the side of the Constitution, the fact that, okay, those funds must go to the Treasury, but I don't have a problem with discussing and expanding on the ability of Justice or EPA requesting from Congress additional funds because of X, Y, and Z. We still have to appropriate, and the appropriation process for the last 20 or 30 years is not what it was designed to be in the Constitution under all administrations. So that's my problem with that, Professor, and if you look like you want to respond to something, so
Yeah,
please
no,
go ahead.
I mean, I think it's a great question, and I appreciate the chairman's concern here. Two thoughts. One, a great example of a case that's sort of happening right now is Volkswagen. Everybody's familiar with the Volkswagen debacle. Volkswagen had defeat devices on a lot of its cars that allowed them to evade the requirements in the United States under the Clean Air Act. There are a lot of victims. I mean, there are a lot of consumers who were defrauded. And I don't see anything in the proposed legislation that would prevent those individual victims from being compensated by Volkswagen.
Please bear in mind, this is just exactly why we're having this hearing.
Right, absolutely.
Oh, okay.
But I think even the skeletal sort of trimmed down version of the bill that we have that we've started with preserves the restitution for those individual car owners.
Yeah.
But what about the rest of us? I mean, Volkswagen's conduct, some news reports have suggested that hundreds of people will die because of the nitrogen oxide that Volkswagen cars emitted into the environment. How do we address that harm?
I don't dispute that with you, but I believe that's Congress's responsibility.
Well, but is Congress going to, so for each of these cases, are we going to have the Volkswagen Harm Act? Are we going to have the Exxon Harm Act, the BP Harm Act? I mean, you see.
No, we're going to go through the appropriation process by which any department or agency requests money for its original budget.
Of course, and EPA, I'm not sure how well their budgets are faring in this Congress, but EPA does have, makes a budget request every year to address air pollution.
Sure.
But my point is, how do we address the air pollution caused by Volkswagen or the harm to the Gulf of Mexico ecosystem caused by BP? The whole idea of these payments is they allow not the taxpayer, but the company involved to pay for the harm that they did in cases where harm is not identifiable to individuals.
And this isn't the time and place to discuss the extent of the damage. I mean, that's for another hearing. But I've used way over my time. Now,
Mr. Chairman, could I just respond a little bit?
as long as my colleagues don't matter? Yeah. Okay. Go ahead.
In the answer, I think we've given an answer to the question. The question is, how do we remediate that damage that was done?
Yeah.
As trained lawyers, we prove it. Seems to me the agency or the Justice Department makes the allegation that this amount of extra pollution has been created. that would seem to me to be evidence of the damages to be paid or additional damages to be paid. Whoever is the appropriate executive branch agency comes to the Congress, makes the case that this additional impact on the environment has occurred, this amount of money has been extracted from the perpetrator, and we believe that using this amount of money or a portion of it to respond to it is appropriate. And then Congress makes the decision. Yeah. It seems, the other thing is, as I understand in the bill, you allow specifically remediation of environmental damage.
Yes.
But it has to be proven. Yeah. It has to be proven. Let's not forget that. We're talking about proving it. And again, if the impact is so diffuse, but you can still get a sum of money for it, run it through the appropriation process where Congress, if it does its job properly, ought to be able to respond in an appropriate fashion.
All right. Professor, you...
Very briefly, the complexity of the problem, somebody's caused a general diffuse difficulty for the American people, can't be resolved by deciding that this particular university or environmental organization should receive money as opposed to this one.
Yeah.
And if that decision is going to be made, it's much better that it be made through the appropriations process than by a Department of Justice official.
Good point. I now beg forgiveness from my colleagues and recognize the ranking member of the subcommittee, my friend Mr. Johnson.
Thank you, Mr. Chairman. I can't resist asking Professor Uhlmann to offer the response that I see he's burning to me.
I have such a good poker face. Yeah, no, I agree with Professor Figley. I mean, this notion of direct, you know, it's a famous case now. It involves the current governor of New Jersey. I won't name him, but, you know, when he was U.S. attorney, funds were directed to his law school, and that shouldn't happen. And I think everybody agrees that shouldn't have happened. I don't know. I even think the governor of New Jersey might agree that was a mistake in hindsight. But it's not the case, as Professor Figley suggests, that environmental prosecutors, my former colleagues, are handing out money to their favorite environmental charities. The practice at the Justice Department, made clear in two separate policy documents. First one that was issued over my signature in December of 2000, and then another that was issued in the Bush administration by Assistant Attorney General Ron Tempest, require that the funds only go to organizations that Congress has already identified as organizations that can receive this type of funding. So I think it's important to sort of describe what's really going on here and recognize that the funds that we're talking about, the funds in the Gibson guitar case that Congressman Lungren has talked about, went to an organization so it could address the harm caused by illegal logging operations. Congress had designated that organization, established that organization to receive this type of funding. It's not going to everybody's favorite environmental groups. It's not going to law schools. But I agree with both of my colleagues on the panel that it shouldn't be going to those organizations, and I'd have no objection to Congress saying that can't happen.
Well, tell me now, if relief must be a direct point-to-point remediation of harms, how do you directly remedy the damage of an oil spill wherein the damage, or whereby the damage is to all of the birds along the shore? So in other words, a bunch of oily birds. How do you directly remedy the harm done to those birds?
Mr. Chairman?
Yes.
I think you do what we've done in the past, which is require the companies responsible to pay for the remediation. Well, it doesn't stop them from hiring. It doesn't stop them from hiring organizations.
How would you do that?
Know how to do that.
How would the company actually remediate the harm to all of the birds?
Well, as they've done in the past, they hire groups that actually go out and do it.
Well,
I don't see any problem with that. I will say this, though.
Well, isn't that a donation?
There's no problem with that as long as it's specifically to, no, If you look at the language of the bill, that is not a donation. It is a service that is rendered as
Well, you're
a result of the remediation. So in that sense, that is not a donation, as I understand the terms of the bill as written.
The order pursuant to the litigation would direct would be to a entity to actually remediate
Right.
harm.
That would be a service. As I understand the language of the bill, that would be allowed. That would not be considered a donation. That's made an exception to the definition of donation. I do know this.
What's the difference?
The difference is that's the way the law was written.
Well,
Secondly, I would say this. I have not been able to see any improvement in the wastewater anywhere that I have been as a result of a $1 million donation to the U.S. Coast Guard Alumni Association.
well, now you take one particular example and try to make it the norm, and I would suggest that that's not the norm. Same way the governor of New Jersey directing funding to his alma mater. It's an anomaly, and we don't want to throw the baby out with the bathwater here. What do you say to that, Professor Uhlmann?
Well, that expression, I think, captures the whole problem here. I mean, there is no question that there are circumstances where this authority could be abused. And we've come up with some isolated examples of where it might have been in the past. I mean, I don't want to be on record saying that, the payment to the Coast Guard, which I'm not familiar with all the details about, or even the Seton Hall donation was an abuse of authority. But they could be, and I think limits on the authority in that way could be helpful. I do think they're already provided by existing policy, so I'm not sure that there's something to add here for Congress. But look, I think clear rules of the road, which is one of the suggestions that Congressman Lungren made, are always helpful. I think clarifying what is and is not acceptable about third-party payments could be helpful. But this misnomer that somehow third-party payments are a way that people are self-dealing, are pursuing partisan agendas, are engaging in conflict, creating conflicts of interest. I mean, it's not the Justice Department I served in. And I served there for 17 years in both Democratic and Republican administrations. And I think it's unfair to describe the government in that way or suggest that that's what's happening in these cases. These are real harms that don't have identifiable victims that the government is trying to address, as it is obligated to do so, to do justice in its cases.
Thank you, Professor. In your written testimony, you observed that the practical effect of H.R. 5063 may be to generate more criminal enforcement of environmental cases. Could the Justice Department have brought the Morrell case you cite in your written testimony as a civil case? And what other types of cases might also be brought in criminal instead of civil actions as a result of H.R. 5063?
Well, Morrell very definitely could have been either a criminal or civil case. I think the evidence that we were able to amass about statements like who's going to jail this month, there was a document that actually said, that detailed violations, and the cover memo said, this document has been destroyed at the plant and should be destroyed by you after reading it. So my fellow former prosecutors will understand why we got pretty excited about that as a criminal case. But the reality under the environmental laws and under most of our public health and safety laws is that prosecutors enjoy enormous discretion about whether any particular violation is going to be criminal or civil. And so, I've written about a lot and focused a lot about the need to exercise that discretion in an appropriate way, to limit criminal enforcement to the most egregious violations. But look, in the close calls, and there are a lot of close calls that we ask the Justice Department to make, and that we trust them to make properly. If they feel like they can redress the harm to the communities if they bring a criminal case, but can't do so in a civil case, it's going to tip the balance toward criminal enforcement, at least in some cases that otherwise might be left for civil enforcement, and that's the concern I was raising.
Thank you, and with that, I'll yield back, Mr. Chairman.
We're all attorneys up here. I don't know if that's a good thing or bad thing, but this is just actually one of the most interesting discussions that I have had the privilege of chairing since I've been here. And the chair now recognizes another prosecutor from the state of Texas, former U.S. Attorney, Congressman Radcliffe.
Thank you, Mr. Chairman. I thank the witnesses for being here today. You know, I've been grateful over the last several months to have the opportunity to participate in something called the Article 1 Project. It's a network of House and Senate members focused on reclaiming, as unnecessary as that may seem, reclaiming the Article 1 powers of Congress and limiting the ever-expanding executive branch. And I think this hearing, I agree with you, Mr. Chairman, very interesting, and it really underscores the critical need for Congress to reassert the separation of powers. In this case, it seems to me especially so in response to what appears to be really an outrageous overreach by the administration and disregard for Congress's constitutional power of the purse. This Department of Justice scheme of funneling money to activist groups, some of those groups where Congress has specifically denied funding, federal funding, is especially troubling as a former prosecutor and someone that's worked closely with the Department of Justice. And equally troubling is that the fact that the Department of Justice, not only have they been less than forthcoming, it seems, in response to this committee's investigation, but essentially have doubled down on a practice that would appear to ignore the Constitution and lacks transparency with regard to the appropriations process that allows the American people to hold their government accountable. And instead, here we see money that should go to the U.S. Treasury going to DOJ-selected winners and losers. In fact, DOJ picking winners and losers from groups that stand to gain from these settlements, and in some cases, who've actually lobbied DOJ to receive them. So beyond the constitutional concerns, I'm troubled by a lack of transparency and a host of ethical issues that this scheme would present, and the idea that a Department of Justice official can direct immense sums of money to a pet organization or political allies with zero accountability is something that I would think would trouble all of us, Republicans and Democrats. So let me start out, Congressman Lungren, great to see you again back here on the Hill. You talked about this grant phenomenon in your testimony at both the state and federal level. I know you've seen it as the Attorney General in California, these grants being these, to quote you, coerced payments to entities that are mandated by officials acting with the full power and majesty of the government. Let me ask you this. First of all, do you think that this scheme that the Department of Justice, in my words, has doubled down on, do you think it violates the Constitution, number one? And secondly, would you, depending on your answer, would you elaborate on why you think the allocation to Congress of the power to spend federal funds is critical to the separation of powers that I talked about? Well,
First of all, thank you very much, a fellow Notre Dame Domer. I appreciate that. I have been concerned over the years I was in Congress at the failure of Congress to assert itself appropriately. And when you study the Constitution, the Constitutional Convention, and the arguments made in the Federalist Papers, it is very clear that they felt that the power to extract funds and to spend funds on the part of the government was one of the potentials for tyranny. And I'm not suggesting we're involved in tyranny, but it is an essential bedrock principle that the Founding Fathers talked about. They made a conscious decision, I think, to make Congress Article 1. The first thing they thought about when setting up the government was the most representative branch of the government. Then they also felt that it was important between the Senate and the House that the House be given primary responsibilities in these matters, even though I think we forfeit that right in some of the legislative legerdemain that takes place, where we send a bill over to the other side, they take everything out except the title, and then they send it back so that the revenue bill didn't start in the House, essentially. But they did that because they knew that the members of the House had to go before the people more often than anybody else, and that therefore, if the average citizen, if the citizenry felt that there was a violation of that trust in that most important area, they could respond. To the extent that gets placed in a gray area, and I think this is, look, if you're talking about a couple dollars here and there, all right. But Senator Everett Dirksen once said, $1 billion here, $1 billion there, pretty soon you're talking about real money. Now, as I understand it, we're talking about $1 billion in just the time that the Congress had the temerity to ask the Justice Department what they were doing. That doesn't sound to me like an olive branch to the House of Representatives. And the last point I would make is this. I happen to applaud what Professor Uhlmann did at the Justice Department. I think you were moving in the right direction. But despite his best efforts, you still had in 2006 that $1 million going to the Coast Guard Alumni Association on a matter of the environment. Madison said it best. He talked about if men were angels, we wouldn't need government. But men are not angels, so we need government. But then he said, once you decide those who are in the government, you have to figure out how to govern the governed. And the answer he gave, as I mentioned in my paper, is you pit ambition against ambition. In one sense, you pit one branch of government against another. That's what we do. And one of the ways you do that is you give primacy to the House of Representatives for spending matters. It is not neat. It is not pretty. It is not the most efficient way of doing things, but that is the genius of our founding fathers, that they thought, as Justice Scalia said many times, the greatest protection for our civil liberties and against their invasion was the construct of government that we set up. And I think that's lost in today's debate, and Congress has got to be one of those branches of government that understands their responsibility, understands their role, and understands the limits of all branches of government. I'm sorry it was a long-winded.
No.
You gave me a chance to.
I enjoyed your answer. Thanks, Congressman. And my time's expired, but if the chairman will beg my indulgence, I have one quick question I really want to ask Professor Figley, because we were both at the Department of Justice. I'm not sure if we were there at the same time. But I'm curious about your experience with respect to the mandatory payments to non-victim third parties. More importantly, how has this practice evolved in recent years, and most particularly, in your opinion, what do you think is the driving force behind this?
I never had anything to do with it when I was at Justice. I mainly defended tort cases, big ones, but tort cases. My concern here is that we saw as our mission in life protecting the judgment fund and protecting the people's money. Here, I think the practice gets away from that. Professor Uhlmann talked about the Gulf oil spill and the money there. There's a $2.4 billion grant to one particular environmental organization, and it may be a perfectly good one. But I think it would have been much better to have had all of the environmental organizations interested in receiving a $2.4 billion grant apply for it and go through procedures where there would be transparency and clarity about where the money was going and why it was going to that particular entity.
I appreciate your response, and I appreciate the chairman's indulgence. With that, I yield back.
Chair now recognizes the ranking member of the full Judiciary Committee, another attorney, Congressman Conyers.
Thank you, Chairman Marino. I welcome all the witnesses, of course. Our former colleague witness here today argued that agency enforcement decisions must be motivated by the public interest and not politically motivated self-interest. And so, Professor Uhlmann, what guidance, what laws currently exist to promote the public interest in settlement agreements, in your view?
Well, I absolutely agree with former Congressman Lungren that is the role of law enforcement. And of course, all the laws that are within the purview of this committee are laws that are designed to promote the public interest, protect the public from a whole host of potential harms. Congress already passed the Miscellaneous Receipts Act, which ensures that that funds that have been directed by Congress can't be redirected by agencies. Congress already passed the Anti-Deficiency Act, which ensures that these sort of third-party payments that we're talking about can't be used to augment agency budgets. The agencies can't have a role in administering the funds. Congress already designated certain organizations to receive payments like those we're talking about. In fact, like the payment in the Gulf oil spill that Professor Figley's talking about, this notion that somehow all the environmental groups should have lined up and petitioned the Justice Department for funding, I mean, respectfully, that would give me far more concern than what the Justice Department did. They made sure that the money went to an organization that Congress already established in the public interest. I happen to share the concern about the size of that payment, but it went, as it should have, to an organization that Congress determined should receive these funds. And then, as I indicated in my testimony, there are a number of policy statements that the Justice Department and the various regulatory agencies have developed to do just what you're talking about, Congressman Conyers. I suppose those could be codified by Congress, but they do exist in each of the various, at the Justice Department and each of the various regulatory agencies.
Did any one want to add to this question?
If I might, Congressman.
Yes, Mr. Figley.
I think that presents a false choice. We have $2.4 billion. Is it for Justice to decide to give it to this organization or to set up a way for different organizations to apply to the Department of Justice for the $2.4 billion? Neither of those is the answer. The answer is put the money back in the Treasury, let Congress decide how the money will be utilized, and if there's to be a grant program, it should be administered through the appropriations process.
Mm-hmm. Mr. Chairman Emeritus. I'm bothered by the example of the Housing and Urban Development Housing Counseling Assistance Program. My last term here in Congress, we voted on some very tough budgets, as you know. We had to eliminate that, we thought, that one year, $88 million. The next year we came back, my very last year in the Congress, we came back with a budget that granted, I think it was 55% of that total. And then we maintained it at that level. That's what we thought in terms of our budget priorities. And yet, if you look at the Citibank settlement as well as provisions in the Bank of America settlement, $150 million worth of mandated donations went to those housing nonprofits, which essentially reversed the decision of Congress. Now, you might say, and we might agree, that housing counseling assistance is an appropriate program. But it seems to me if Congress, looking at all the priorities out there, made the decision that it could only be funded at half of what it had been before, then that money should be, that additional money ought to be determined by Congress, not by HUD.
All right, let me close with this final question about Mr. Figley's recommendation that H.R. 5063 apply to criminal settlement agreements. Professor Uhlmann, what effect would that have on criminal enforcement cases?
If this type of language also applied in criminal cases, it would just shut down the Justice Department's ability to address a lot of the harm that's caused by criminal violations of our public health and safety laws. And it would give corporations a free pass for the harm they caused. Now, Congressman Lungren suggested, go prove it in court. But so much of the kind of harm to communities, harm to society that we're talking about is not possible to prove, certainly not beyond a reasonable doubt, and even by clear and convincing evidence, or it's not possible to monetize. And it's those companies, not the American taxpayers, who should be addressing that harm. And so It's particularly important to have this authority in criminal cases, because if our criminal authorities are being exercised properly, those are the worst violations that cause the most harm. And the companies who engage in that misconduct should be held accountable. And I worry if the committee were to accept Professor Figley's recommendation, it would just make a potentially bad bill worse.
I think you're probably right. I know we could continue this discussion, but my time has expired, and I thank you all for this very important hearing.
I do have one more question I'd like to throw out to all three of you gentlemen, but I'm starting to get flashes back of law school when we talk about the proximate cause in Cardoza and Paul's graph and the whole 9 yards. I mean, that can go forever. But Professor Uhlmann, there's no question that I support the fact that justice, the agency, can see that those that are directly injured receive the funds to compensate and to even go further than compensating. But let's talk a second about the banking settlements, which trouble me. Mandatory donations that did not conform to EPA guidelines that you cite with respect to the amount of credit given for donations. There's credit given, lack of oversight. There's lack of oversight in all this. That's probably in addition to the issue concerning Congress controlling the purse strings. That's the next thing that really bothers me, the lack of oversight. Where's it going and why? Augmenting agency funds by reinstating funding Congress specifically cut. So what say you?
No, I think the chairman's concerns are reasonable. I mean, I understand where you're coming from, and I think, in the area where I worked, which wasn't banking, there are pretty clear rules of the road that are governing how the Justice Department and EPA exercise this authority. If that needs to be done across the government to ensure that other sectors have similar rules, then that should be done. Whether the best way to do it is legislation or whether the best way to do it is policy statements, I defer to the committee about, or the subcommittee about. But I would say this: if the subcommittee were to legislate, I mean, I think it's far better to legislate through positive rules that say these are the things you're allowed to do. And certainly then to add, and these are the things you're not allowed to do if there are things that we think are good. And I think there's actually a lot that we would agree is good. I think we don't want, in fact, I think your opening statement, or perhaps it was the full committee's chairman's opening statement, recognized that there can be generalized harm. And companies should be on the hook for that if they break the law. And, we shouldn't lose sight of the fact that companies that break the law get a significant advantage, competitive advantage against other companies who follow the law. And so, they're properly punished when they break the law, and if they cause harm, they should compensate the communities that have been harmed for doing so. And so, I certainly felt this sort of all grew up when I was at Justice, and I did feel at times like we were kind of in an open field where there was the potential for the kinds of things that the chairman's described happening. And so I really wanted rules. And I even might have thought at some point that maybe Congress should write those rules. But Congress wasn't writing them, so we wrote them. And we tried to be principled, notwithstanding the fact that one case happened on my watch, although it was a case brought. I now know which case Congressman Lungren's talking about. It was brought by the U.S. Attorney in Connecticut. Oh. My office was not involved. I think it was a deferred prosecution agreement. We didn't do those. But the bottom line is there's so much good here and there's so much bad that happens that we need to address. And I think it's good to address that. We want the government to address that. We're not taking money away from the taxpayers. We're not taking away the money that this Congress and every Congress has the Article I authority to appropriate. We are saying corporations should pay for the harm they cause, and we don't want, and I think it'd be a shame if there was legislation that let companies off the hook and prevented the government from being able to address those harms.
Professor Figley, would you like to respond? You don't have to, but if
Well,
you'd like to.
very briefly, nobody's saying let corporations off the hook. The question is, when you get money from them, who should decide where that money goes? And that's something that I don't think the Department of Justice should be in the business of doing. And I have the highest opinion of the Department of Justice and the attorneys that work there. It is a bulwark of inertia in the very best direction. Throughout the department, people do what they think is right. They don't try to serve their own purposes. But it shouldn't be the business of the Department of Justice to dole out money, particularly grants of billions of dollars.
Mr. Chairman,
Professor,
I have the greatest respect for Professor Uhlmann. I really do think he did very good things in the department, leading in the right direction. Two of his responses caused me pause, however. In the one case, he said, if this bill were to pass, there would be a tendency, perhaps, for officials of the Justice Department to move cases from civil side to criminal side. But then in response now to if it applied to the criminal side, it would be, we couldn't go forward because you have to prove guilt beyond a reasonable doubt. I think the dilemma lies in what do we believe about proving cases? As prosecutors, we all know, and in California, I was responsible for the ultimate cases, the death penalty cases. We all know in our gut people that were guilty that were never successfully prosecuted. Why? Because we couldn't prove beyond a reasonable doubt.
Sure.
That's the way the system works. And for some reason to be hung up on the fact that, man, if you have to go to court, you got to prove these cases, and we've got to prove what the dimensions of the harm are, bother me. That's what we do. That's part of the requirement in our system, and we don't catch all the malefactors that way, and we don't punish all the harm that has been done because the system is set up that to protect the innocent, we accept those things. So I would like us to have more proof regarded in these things, and then with respect to the money, the only reason these monies are given is because of the power and the majesty of the government. I used to remind my prosecutors, you know, always keep in the back of your mind you could be wrong. Because if in fact you have someone who is guilty, you should bring the power and the majesty of the government against it. But if you haven't, think how unfair that is to an individual. And so there's a certain sense of humility that we have to maintain in all this. And I do believe, and I firmly believe this, with the people that worked with me at the California Department of Justice and with those that I know at the U.S. Department of Justice, they are good people. They are trying to do the right thing. But sometimes even good people have to have guidelines that of restraint, and the Constitution gives us that. And maybe we ought to look at the Constitution occasionally.
Yeah. Well, gentlemen, this has been an incredible discussion. I have the utmost confidence and faith in the frontline prosecutors. If we learn to keep the politics, not pointing the finger at anybody, out of this, I just sleep better at night knowing that the kind of prosecutors that we have, not only at justice, but at state and local levels. And I certainly appreciate what you've contributed today. Okay. Yeah. You have some question? Go ahead. Yielding now to gentlemen for further questions.
Thank you, Mr. Chairman, and I associate myself with the remarks that you are in the process of making about, about our dear friends here. But I would like to ask Professor Figley, since you served in the civil division of the Justice Department, have you had any experience showing that unlawful conduct was the direct and proximate cause of an injury, direct and proximate cause? I mean, that's a standard that does not currently exist in civil enforcement actions. Is that correct?
I fought against that in a number of cases brought against the government. Occasionally, we would bring big suits, And I had $1 million settlements in a case where a corporate officer parked a car in high, dry grass in a national park and caused a huge forest fire. And another case where there was a government-owned irradiation facility where a capsule holding radioactivity cracked and contaminated the whole facility, and it was worth millions of dollars. And there we'd have to prove it up, or show...
You have to prove proximate cause.
Yes. Did the defendant's act cause, in fact, what happened? And was it connected close enough in time and space, and you talk about Paul's graph, and what seems reasonable to people making hard political choices, that it's close enough to establish liability. And in those two cases, we were able to convince the defense attorneys that we had the goods. When your car starts a forest fire because of the catalytic converter, there's not much question. And there wasn't much question with the cracked capsule. So we were able to prove our cases and accomplish the settlement.
Well, direct and proximate cause being a new standard that is proposed by this legislation, so proximate cause is not the same as direct proximate cause, is it? That's kind of like a heightened standard. There is just absolutely no deviation between points of causation.
When we talk about causation in negligence, there's two parts. First is cause in fact. Right. Did what you do, if you hadn't done it, it wouldn't have happened. So if you were speeding down the New Jersey Turnpike, going 40 miles over the speed limit, and when you got to Maryland, you drove cautiously, and you hit a little old lady walking across the street, your action of speeding through New Jersey for 2 hours was a cause in fact of your hitting the little old lady, because she wouldn't have been in the street if you'd gotten there later. Now the question about liability then turns on, is there proximate cause? Is this close enough in time and space that the law will say, yes, there should be liability, or is it too far removed? Mm-hmm. And most courts would say speeding in New Jersey 4 hours ago is too far removed to impose liability. But to establish liability, you have to prove both parts. And I don't see a difference between direct cause and cause in fact, which is what I'm talking about.
Yeah, I mean, if that same person speeding ran up on the curb and hit a ladder upon which someone was washing windows, and then that person fell off the ladder and went through the windshield of a car, I guess, yeah, I mean, a direct and proximate cause.
There's clearly direct cause. Now, whether you're going to have proximate cause and liability is the harder question.
I guess I'm trying to come up with a scenario where you may not have a direct cause, but you do have causation that was proximately caused. You do have a damage that was proximately caused as opposed to directly caused. And I'm just curious as to why the language direct and proximate cause appears in this legislation, and I wonder what effect the requirement of having to prove direct and proximate cause would have on secondary remediation of unlawful conduct.
I would see the proximate cause part being a limitation, so that if there's a direct cause, there also has to be a proximate cause. But the direct cause is the easy one. If it wouldn't have happened but for this thing going on, there would not be a direct cause.
It's definitely a heightened requirement of proof. Is that correct, Professor Uhlmann?
Of course, I teach criminal law, not tort law. But I mean, I think Professor Figley's right that there are two separate causation concepts that govern both criminal law and tort law. I mean, causation is an issue in the criminal law as well. And so there has to be actual cause and fact. There has to be proximate cause. This term direct does come out of, I'm not sure where it comes from. So, we're not, the chair said we're not in markup. If we were, I would suggest that a better term would be actual rather than direct, which is, I think, the correct term from tort law. Although, frankly, and I think this is what Professor Figley was suggesting, proximate cause by itself would be sufficient, because something can't be the proximate cause without also being a cause in fact. Something could be a cause in fact without being the proximate cause. So we tend to focus on proximate cause, although it does need to be a link in the chain of causation to be proximate, to proximately cause something.
In some states, the elements of negligence are listed as duty, breach of duty, proximate cause, and damages. In other states, they're listed as duty, breach of duty, cause in fact, proximate cause, and damages. So, as with so many things, it varies with state law.
Well, thank you, and I will conclude by saying that Professor Lungren, you've missed your calling. I think you should be on the academic side also. But thank you all.
Thank you. I think in closing, I can shed some light on direct and proximate calls that's specifically delineated in the Crime Victims Act, Title 18, USC, Section 3771C, and right here. In general, the term crime victim means a person directly and proximately harmed as a result of the commission of a federal offense or an offense in the District of Columbia. So, I mean, we make a lot of, I'll tell you what you folks did for me today. Tonight I'm going to have nightmares about law school exams, okay, with proximate and related and direct, and how far do we go from, as my friend's example of, the speeding car hits a ladder, the guy falls off the ladder through the windshield, the guy in the car hits somebody else, destroys this.
Sounded like a law school hypothetical, didn't it?
I don't even want to even think of that. It's gonna
I
bring
think
back
that was in
a lot
Mad,
of
Mad, Mad
memories.
World.
Yeah. Thank you so very much. This concludes today's hearing. I can't tell you how much that we have enjoyed this discussion. Please do not hesitate, if you care to send us recommendations, additions, deletions. This is how good law is made. We sitting up here just because we're, of course, we congressmen, as soon as we get elected, we think we're taller, smarter, and better looking. But this is how good law is made, when we reach out to everyone who has a dog in the hunt and the expertise of people like you, so we don't have to go back, and we can't anticipate everything, but I think my colleague will agree with me. Having discussions like this just is the right thing to do. So without objection, all members will have 5 legislative days to submit additional written questions for the witnesses or additional materials for the record. This hearing is now adjourned, and thank you very much.